Hi, I'm Noah Weisberg.
And I'm Doreen So.
Welcome to Holland Estates. You're listening to episode number 554. How are you doing?
I'm good. How are you?
I'm doing well, thanks. I think we've got a interesting discussion for today's podcast. We're going to be going through a recent decision out of Hong Kong as it pertains to steps a solicitor should take when drafting a will and the possible consequences in relation to a will challenge and how that applies in Ontario.
Right.
The decision, as I said, is from Hong Kong. It's Choi Po Chun, and the court file is CACV 177 2014. And just a bit of background with respect to the decision. It was a will challenge which dealt with a 92-year-old testator, lived in a care home, and showed physical signs of infirmity. A will was prepared, it was challenged, the will was found to be valid at the lower court, and the Court of Appeal set aside the validity of the will in favor of a prior will. So nothing new, nothing exciting, your standard will challenge, but what we thought was interesting was the test that the Court of Appeal applied as to the steps the solicitor took when receiving instructions in relation to the capacity of the testator and in turn whether the will was valid or not.
Right. And Hong Kong, as a former Commonwealth jurisdiction, still applies Banks and Goodfellow, the same test that we apply here in Ontario. But in Hong Kong, they seem to follow a golden rule that was set out in the UK. It's a very interesting golden rule for drafting solicitors in that it is actually something that has a name. It's called the golden rule because it's the golden standard. And whenever you're dealing with an actual aged or seriously ill testator, this rule requires the drafting solicitor to involve a doctor as one of the witnesses to the will, and that doctor is tasked with examining the testator physically and assist in the inquiry on the issues of capacity while the solicitor deals with sort of like the rest of the legal tests involved.
Yeah, so I think in this specific case, there were a lot of red flags that the court noted. As I said, 92 years old, living in a care home, showed signs of infirmity. The instructions were apparently given by someone other than the testator. When the solicitor met with the testator to execute, they read it over with the testator the first time, didn't understand the contents, read it over a second time, and finally understood the contents. And the court basically said that the test in Banks and Goodfellow was not met, but importantly, what the solicitor should have done was basically three things. The first thing they should have done was gone through a detailed analysis with the testator, asking specific questions based on the complexity of the will. They then said that the solicitor should have applied specifically the checklist set out in the Assessment of Mental Capacity, a practical guide for doctors and lawyers published by the British Medical Association. So not just any checklist, but a specific checklist put forward by the BMA. And then lastly, what you mentioned, the golden rule. They actually say that a doctor, practitioner should come and witness the will and ask specific questions in that regard. And, it's interesting because I think that these are things which some solicitors do in Ontario. I don't think it's ever been compartmentalized in one specific case, but we certainly recommend to solicitors when they have concerns over the age or frailty of their client that if there are any concerns, go get a good capacity assessor, have them assess capacity at the time instructions are made, and assess for capacity when the will has been executed, and keep that assessment close by should the will be challenged at a later date.
Right. But in terms of sort of talking all around of what you are assessing and sort of what this checklist is supposed to be for, we do have to ground it back to the Banks and Goodfellows test, which is what does a testator have to know in order for a will to be valid. And the test for testamentary capacity has to do with sort of 3 to 4 prongs in that you actually have to know what a will is, what it does when it comes to effect. You also have to know what you are giving away in terms of like what do you actually own,
Mhm.
what do you have, and who are you giving it to? And when it turns out that you may be cutting off certain beneficiaries who would naturally think they have an entitlement to your estate, you have to turn your mind to them and consider the claims that they might have and all those things, which is very helpful to like go through things like a checklist, very helpful to involve a doctor.
Mhm.
In terms of, say, some of the best practices in Ontario, case law in Ontario has said, sometimes depending on sort of like the circumstances of the person, how sick they may be or how old they may be, it it could be problematic if you don't actually go get a mini mental status examination. It could be problematic if you don't really explore certain like suspicious circumstances, like having family members give instructions, things like that.
So yeah, and I think just that to close it off, you're referencing the decision of Hall and Bennett, where they kind of go over failures of solicitors when making wills. So really interesting case. Love how it compartmentalizes what solicitors should do when preparing a will. But I do believe that concludes our podcast. Until next time, we want to thank you for listening. I am Noah Weisberg.
I'm Doreen So.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog. Thanks, Doreen.
Thanks for listening.